All right, I call this meeting back to order. I feel like it's one of those like last time on Judiciary Finance. We left off with Representative Feist Bill 4822. So House File 4822 as amended is before us, and we are about to start committee discussion. So we'll move on to member discussion of House File 4822. Representative Niska.
Thank you, Madam Chair and Representative Feist. I thought the comments of the attorney from the Pacific Legal Foundation were pretty interesting and I think somewhat concerning to me. They obviously have quite a bit of expertise in this area, looking at this issue in a lot of different states. And so I just was curious to what degree you've been able to engage with them, or that they've been able to give you feedback. I did try to have a conversation with them afterwards, but haven't gotten a lot of substantive, and they didn't have a chance to give a lot of substantive suggestions here today. So I just was curious if you could talk about that.
Representative Feist.
Yep, we have had a good conversation, an email exchange, and they sent a very helpful memo that I've read half of. But I think the question is, do we want a process that would be driven by a claim? Or is there a possibility of a workable solution that would allow that automatic refund of the excess tax proceeds or excess proceeds of the sale without that claims process? I do ultimately think, just based on the reading of Tyler, that under Nelson versus the City of New York, that having some type of claims process is not inherently an unconstitutional violation of the takings clause. But I also have had a lot of really good conversations with like legal aid and the AARP, and I think, like, to the extent that we can make this as easy as possible for vulnerable homeowners, we want to do that, of course. And so I've had many very good conversations with nonpartisan staff and with the counties and with many, many stakeholders. And it's definitely clear that having a process that's driven by some type of claim is a much more straightforward option. And so if we're going to go with the claims-free process, we just need to take into account really complicated questions of, like, what if the homeowner is disappeared? How long would the county have to, like, hold on to that money before it would, like, default to the state and still be constitutional? Like, there are just a lot of, like, practical questions. But yeah, we've had really good conversations, and I expect those to continue.
Representative Niska.
Thank you, Chair Becker-Finn. Thank you, Representative Feist. That's good to hear. I think, a couple things in there that I think I want to emphasize, I hope that we're working towards. One is, obviously, it's very important that we do fix our statutory scheme so that we're not leaving our counties as targets to litigation going forward. And I do think it's really important. And I haven't dug as deep into the case law as you have, I think, about whether we need whether a claims process is fine or whether we need some other process. But as much as we can do, I think, to not have a quick trip for for the property owners to have a takings problem, I think is good. So I was wondering if you could talk a little bit about, I guess, if we pass this out, what's the process? How do you foresee the process going forwards in terms of coming to something that's a final product?
Representative Feist.
So what we're trying to do with this really urgent, complicated undertaking is make sure that just like it's very open communication and conversations amongst all the stakeholders, so that any decisions we make, we're making in tandem, and ideally not wasting nonpartisan staff's time coming up with ideas and then backtracking. So the process has been complicated. But I think it's really important that we don't do what's easiest because it's expedient, and that we really do take a really close look at the constitutional questions, the practical questions for the counties, and then just the philosophical questions of how do we protect the property rights of vulnerable homeowners. So I don't know if that quite answers your question. It's been a lot of conversations happening as quickly as possible.
I think, and you'll notice it's House File 4822, so I know it was introduced a little bit late. I know it's going to environment and then taxes. I will say too, I've been fully nerding out on this one too, and it is one of the more complicated legally of the bills we've discussed. So I've talked to some stakeholders as well. I know there's desire to make sure we get this right. So I'm sure Representative Feist will keep working hard as she always does. Representative Niska, anything else?
Yeah, thank you, Chair Becker-Finn. I just wanted to say, it's really important that we do get it done and get it done right this legislative session, and I'm interested in helping out to the degree that that is helpful to get it across the finish line. But it does, and I appreciate that this has come late. It does look to me like you are trying to, you did offer something in good faith to try to get to meet all those goals, and so I am interested in trying to help out to the degree that I can, so, thanks.
All right, any further discussion? Closing comments, Representative Feist.
I think we covered it. I was hoping that we'd have more like complicated constitutional debate, but I guess I'm glad that we're all on the same page that we want to do this well and we want to do it quickly. So Representative Niska, I wrote down that you're interested in helping out, so beware. I will be reaching out. So thank you. Please support this bill as it moves to the next committee.
Yeah, maybe we'll have to start a different kind of nerd caucus. Representative Feist.
Bipartisan.
Representative Feist renews her motion to refer House File 4822 as amended to the Environment and Natural Resources Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you, Representative Feist. And thank you, Mr. Rogan, for coming back. Next up, let's see, we're skipping that one. Representative Curran. Representative Curran, would you like to move to recommend House File 4276 be placed on the general register?
Yes, that is my motion. Thank you, Chair.
All right. Don't have any amendments, and I don't have any public testifiers signed up. Are there any members of the public wishing to testify on this bill? Somebody waved, and I didn't know if he was waving because he wanted to come up or not, but not seeing any public testimony. We'll move on to the bill. Representative Curran, please tell us about the bill.
Thank you, Chair and committee members. As you can see, the language is pretty short here. House File 4276 simply directs the revisor to update outdated terminology in statute where spousal relationships are referenced.
All right, pretty straightforward.
Pretty straightforward.
Committee discussion. Members, any discussion? Representative Finke.
Thank you, Chair. Yeah, thank you, friend. This is nice, and I'm grateful that you brought it.
Any further committee discussion? All right, Representative Curran, would you like to renew your motion that House File 4276 be placed on the general register?
Thank you, Chair. That is my motion.
All right, all those in favor, please say aye. Aye. Opposed? No. Motion prevails. I don't know if you beat Representative Tabke, though. He was really fast this morning. We have Hollins here. Yeah. Representative Hollins. We're going to do House File 3830 first. I will move to recommend that House File 3830 be placed on the general register. Welcome to the committee. Please tell us about House File 3830.
Right. Thank you, Chair. Thank you, committee members. House File 3830 is a very, very simple bill. It is simply striking the language that says a man and a woman can enter into a prenup, and it says two people instead, because as you all know, same-sex marriage is legal in the state of Minnesota as well as around the entire country, and therefore everybody gets to protect their assets in the way they want to for an antenuptial agreement, and I hope you can all support this.
All right. No testifiers signed up. Are there any members of the public wishing to testify on this bill? All right, we'll move on to member discussion. Members, any discussion to the bill? All right, this is an easy one. Representative Hollins, closing comments.
I was hoping that we could be even faster and beat Representative Curran, but I guess.
Maybe, I wasn't timing. I will renew my motion to recommend House File 3830 be placed on the general register. All those in favor, please say aye. 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 Opposed? No. Motion prevails. Thank you, Representative Hollins. I don't think this one's going to be as fast. I will move to recommend that House File 3567 be placed on the general register, and I know that we have a DE. So I will also move the DE1 And then we've got an A3 to the DE1. Okay.
That's correct.
And Representative Hollins, my understanding is the A3 to the DE1 amendment to the amendment just fixes cross-references. Is that accurate?
That is correct. Yep, it just, there's a couple of cross-references in the final bill that it needs to amend.
All right. All those in favor of the A3 to the DE1, please say aye. Aye. Opposed? Motion prevails. All right. And now we're to the DE1 as amended. It's a DE, so I know it's cutting the bill from 58 pages to 14. All those in favor, please say aye. Aye. Opposed? All right, motion prevails. The bill is now in the shape that you would like. Representative Hollins, please tell us about House File 3567.
All right, thank you so much, Chair. Thank you, committee members. I appreciate that. Yeah, we are going to balance that very quick bill with a very long one, and I apologize ahead of time. As I mentioned before, Minnesota passed marriage equality into law in 2013, and as part of that created gender-neutral recognition for legally married couples across Minnesota's laws. The U.S. Supreme Court also held in Obergefell versus Hodges that laws barring marriage between two people of the same sex are unconstitutional. However, a decade later, the underlying law in Minnesota does not fully reflect these decisions, and that lack of recognition is harmful to parents and children in our state. Minnesota law does not define clear pathways to parentage for families who use forms of assisted reproduction, such as IVF, despite how common these practices have become in our state and country. Minnesota lacks clear and comprehensive statutory guidance related to surrogacy agreements and how to establish the parent-child relationship for children that result from surrogacy agreements. Also, as a result, many parents, such as unmarried LGBTQ+ parents, must go through an onerous second parent adoption process in order to become legal parents to their own children. The absence of clear, efficient pathways to parentage is harmful for families across Minnesota. The legal processes that are currently needed, such as second parent adoptions, are often lengthy, costly, and place undue stress on parents and children. The lack of clear parentage pathways also creates confusion and litigation, and children are left more vulnerable because they are securely attached to only one of their two parents under the law. And that means, this means that a parent may, for example, be unable to make emergency financial decisions for their child because he or she is not fully recognized as the child's parent. This bill comes out of recommendations from the 2017 Uniform Law Commission and tailors those recommendations to Minnesota statute. The Uniform Law Commission brought together a broad and expert stakeholder group, including family law attorneys, child protection officials, and public health experts, who worked in 2017 to create a best practices framework to establish parent-child relationships in state law. Since then, bills similar to HF 3567 have been passed in 7 other states and are introduced in 3 others besides Minnesota. This bill, as amended, puts initial building blocks of the larger Parentage Act into place. And I've got, I'm going to walk through the bill in a very high-level sort of way because I understand that it's pretty dense, and I want folks to have a good sense of what we're doing here. So the first section of the bill sets out the definitions. The second part of the bill addresses assisted reproduction without surrogacy. Section 2 states that a donor is not a parent. Section 4 says that an individual who consents to assisted reproduction by another individual with the intent to be a parent of the child conceived is then a parent to that child. Section 5 addresses how that consent process works. Sections 6 and 7 address dispute of parentage by a spouse, as well as the effect of a dissolution of marriage on parentage that is established. And the remaining sections describe what happens in related to parentage in several specific situations, like if there's a dispute in parentage by the spouse, a dissolution of marriage, an individual that had previously consented to be a parent and wishes to withdraw that consent before the IVF transfer takes place. The third part of the bill addresses gestational surrogacy agreements. Section 10 defines the parties that are eligible to enter into the agreement. Section 11 establishes requirements for gestational surrogacy agreements, including the process for creating them, the required content, and the parameters around payment. Section 12 addresses how a change in marital status affects the surrogacy agreement. Section 15 outlines how an agreement can be terminated. Section 16 establishes parentage under a gestational surrogacy agreement, and the remaining sections relate to the death of an intended parent, order of parentage, and enforceability of the surrogacy agreement. And then finally, the final section of the bill sets standards for the treatment of information about a donor. And we can certainly get into that, but in short, sections 22 through 25 name the type of information that a gamete bank or fertility clinic must collect from a donor, including identifying information in medical history, and what information is disclosed and to whom, what choices the donor has relating to that disclosure of information, and related record keeping. So I have several testifiers who I would like to have testify. I was going to say invite up, but I don't really get to invite them up.
Good catch. And first up, I have Kat Roan, and then I have Claire Sorman on deck. Welcome to the committee. Please introduce yourself and proceed with your testimony.
Thank you. My name is Kat Roan. I am the executive director for Outfront Minnesota, our state's largest LGBTQ advocacy organization. And thank you to the committee and to Representative Hollins for this discussion around the bill. Parentage and families are an important part of LGBTQ communities, as they are for all of our communities, and we believe strongly in having laws that reflect the breadth of our family experiences and all the pathways that folks take to reach parentage. This bill and the language in it are adapted from the Uniform Law Commission's Uniform Parentage Act. So these are coming from a national group of multi-party organizations, politicians, folks engaged in these communities who have looked at these very complex and important pieces of law and have made these recommendations that we're bringing forward into Minnesota statutes. And so we believe that these are strong pieces of language that are necessary for bringing Minnesota's laws into a post-same-sex marriage equality world. We consistently hear from LGBTQ individuals and families that there are challenges to establishing and recognizing parentage here within the state of Minnesota. And while that may seem trivial to folks whose parentage is recognized readily, for those individuals that can cause a lot of concern for what might happen if they're traveling out of state or seeking medical care, or if there are issues that come up in their relationship. And so having these clear pathways and clear legally established guidance for this is deeply important to LGBTQ families. But this is not solely for LGBTQ families. It is for all families who might seek assisted reproduction, IVF, and other pathways to parentage. And it's crucial that here as a state, as we continue to update these laws, that we bring them into the best practice across the nation. This is one and an important step in making that process happen, and we look forward to continuing to working with you all and the stakeholders as we work to adopt more of the uniform law.
Thank you for your testimony. Next up, I have Claire Sorman, and then I have David Gapin. And when I call your name, if you want to come up and get ready to testify, that would be great. Welcome to the committee. Please introduce yourself and
Good
proceed.
evening, Madam Chair, Committee. Thank you very much for hearing our testimony today on this important bill. My name is Claire Sorman, and I am the owner and program director of the Surrogacy Center. For the past 7 years, I have been helping to build families here in Minnesota and assisting intended parents in achieving their lifelong dreams of parenthood. There are two groups of folks we serve: hetero couples who have experienced infertility issues, and LGBTQ couples who need assistance in building their families as well. For our clients fighting infertility battles, most of them have gone through years of heartache, failed transfers, losses, and the associated grief that comes with not being able to carry a pregnancy. IVF helps these couples achieve their dreams, and gestational surrogacy opens the door for them to make the impossible possible. Our gestational carriers who are matched with these intended parents are carefully screened, altruistic women who become surrogates to help others who are unable to have children on their own. They all do this because they are passionate about helping people, and they are never, ever coerced into acting as a surrogate. Our agency, as well as every surrogacy agency that I am aware of in this country, adheres closely to the rigorous surrogacy guidelines set forth by the American Society of Reproductive Medicine, or ASRM. In the years I've been working with these families, and for the 22 years that the Surrogacy Center has existed, I have had 0 clients who have expressed regret or dismay about this process in any way, and we have also had never had any lawsuits or legal actions promulgated against us in all of those years. As a member of SEEDS, the national ethical organization overseeing best practices in surrogacy, the experience is the same. You may hear from anti-surrogacy groups that the process isolates and commoditizes women, which could not be further from the truth. They will cherry-pick data and give rare examples where folks have had negative experiences and try to paint a picture that this is the norm, which is ultimately driven by willful misinformation in order to disguise a particular agenda. Our mission is clear here: to build loving families in a safe, legally protected way. Here's just a couple of direct quotes from our clients, and then I'll wrap up. Some of our IPs, JP and PC. We have been trying to start a family for 4 years, but have unfortunately experienced several heartbreaking losses along the way, including our son at 19 weeks and our daughter at 29 weeks. We have so much love to give, and we are so excited to finally become parents. We are in awe of your generosity and so grateful for your willingness to give us the biggest gift we could ever hope to receive. And then from a GCLS. I will admit that in spite of using IVF to build my own family, I was ignorant to what surrogacy really involved. It's not some far-fetched celebrity status act. Surrogacy is a beautiful team effort between willing carriers and the entrusting, grateful intended parents. When I realized surrogacy was on my heart, I knew I needed to find an agency that viewed surrogacy not as a business transaction, but as a safe, ethical, and meaningful journey. Knowing that my own family and my intended parents were legally protected by all of the what-if scenarios and the uncertainty of what a pregnancy can yield gave me great peace of mind as we navigated the medical side of surrogacy.
If I could
So-
ask you to wrap up.
Yep, in conclusion, I'm glad that you guys are listening to this testimony today, and surrogacy isn't going away. We're going to continue to grow as a family building option, so we believe it's integral to protect all parties involved by codifying this into state law. Thank you.
Thank you. Next up, I have David Gapin, and then I have Jason Adkins on deck.
Thank you, Madam Chair.
Welcome to the committee. Please introduce yourself and proceed.
My name is David Gapin. I am an attorney in private practice. I practice in family law, and specifically, I do a lot of just assisted reproductive technology work. I'm very much regretting not preparing a written statement now that I'm standing or sitting in front of you. However, I think it's important to think of where this bill came from. More than a year ago, a group of attorneys convened a work group and put this together. We have combined, I believe, over 100 years of experience. I myself have been in private practice for 20 years now. When I started in private practice, gestational surrogacy agreements were already happening. So I think it's important to note what this bill is and what it is not. What it is a codification of already existing law. We are not changing the law. The court back in 2007, 2008 already has held that surrogacy agreements are enforceable. They're not against public policy. Surrogacy is happening. I have represented hundreds of gestational carriers and intended parents. There's never been an issue with challenging parentage. I've never had a problem, never had it come back to bite me. It is going to continue to happen. And what this bill does is create a set of procedures and rules to create uniformity across the state. Right now, depending on what county you're in, there's different procedures for establishing parentage, a different method. And so it's county to county, judge by judge. And so this bill fixes that. It actually creates some additional procedural safeguards for what has to go into gestational carrier agreements that don't exist under current law in terms of representation, in terms of age, and psychological evaluations. So these are all important safeguards. And the speakers against this bill, those are the people who are advocating a change in Minnesota law. That would be a difference in terms of restricting it or in terms of outlawing it. And with that, thank you so much.
All right, thank you for your testimony. Next up, I have Jason Adkins, and then I have Patience Griswold on deck. And Ms. Griswold, if you're here, if you can go ahead and come on up so we're not wasting time in between waiting for people. Please introduce yourself and proceed with your testimony.
Good evening, Chair Becker-Finnan, members of the committee. I'm Jason Adkins, Executive Director of the Minnesota Catholic Conference, the public policy voice of the Catholic Church in Minnesota. We're here today to testify in opposition to Representative Hollins' bill and hope that instead the delete all amendment gets adopted, which embraces the recommendations of the Legislative Surrogacy Commission. Though we can certainly understand the natural desire to have a child, and the Catholic Church is about the last institution that can be accused of being against bringing more children into the world, we must consider in greater detail the effect of surrogacy arrangements on the parties involved, and also the way in which surrogacy arrangements can have broader social consequences. And these concerns, certainly the Church is not alone, and its concerns cannot be written off as mere religious objections. Beyond faith leaders, a diverse array of anti-poverty advocates, those concerned about human trafficking, bioethicists, scholars, and feminist leaders have all expressed reservations about surrogacy precisely because of some of those challenging stories that you can easily find with a Google search. Among those concerns, first, the emerging physical and psychological problems that surrogates and children born of surrogacy arrangements are being shown to have suffered because of hormone treatments, the severance of the gestational bond, and other factors, including the intentional decision to raise a child and bring a child into the world without being raised by one or the other of the mother or the father. Second, the business practices of surrogacy brokers in some states and around the world, some of which have been shown to treat women like chattel and foster human and reproductive trafficking. Third, the fact that surrogacy arrangements allow people with money and means to do an end run around the adoption process, which is the normal, state-approved way in which people terminate parental rights and which has extensive protections for parents, the birth mother, and the child. Again, the solution here is to recognize that there is no existing legal framework for surrogacy arrangements in Minnesota. So the question is, which one should we adopt? Our position is that the regulations in the Delete All Amendment that do not ban surrogacy, but only ban the for-profit commercial enterprise of surrogacy, are the ones that we should embrace. Thank you very much for your attention.
All right, thank you. I have Patience Griswold, and then I have Rebecca De La Hunt on deck. Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair and members. My name is Patience Griswold. I'm the engagement coordinator at Them Before Us. Under this bill, what makes someone the parent of a child is not the natural biological bond that exists between them, nor adoption, an arrangement that is designed with the child's best interest in mind, and thus requires rigorous background checks and screening of the adults involved. Rather, it establishes parentage on the basis of intent. This change turns children into commodities to be awarded to adults with the money and means to acquire them. Furthermore, surrogacy creates a class of people who can be sold. A child who is genetically related to the woman who carries him cannot be exchanged for money. In commercial surrogacy arrangements, a child who is created with donor gametes and carried by a surrogate can be. Even when a child of surrogacy is raised by their genetic parents, they experience the trauma of maternal loss when they are separated from their birth mother. Mother-child bonding begins in utero. By the time a baby is born, she knows her mother's voice and smell and has been responding to her emotions. Studies show that maternal separation is a major physiological stressor for an infant, and even brief maternal deprivation can alter the structure of an infant's brain. We urge you to consider the perspectives of those who have been victimized by this industry. Brian, a child of surrogacy, wrote, "Babies are not commodities. Babies are human beings. How do you think it makes us feel to know that there was money exchanged for us?" Olivia, another child of surrogacy, put it this way, "I lived it as an abandonment. I feel as if I was abandoned by my birth mother." Additionally, research has found that 70% of donor-conceived adults believe that society should not encourage gamete donation, and 62% said that they found the commercial nature of gamete donation to be unethical. Children are people, not products to be commissioned, swapped, sold, or traded under contract. They deserve to have their rights protected. As one donor-conceived individual put it, third-party reproduction is not a new way to create families. It's a new way to rip them apart. Thank you.
Thank you for your testimony. Next up, I have Rebecca De La Hunt. Welcome to the committee. Please introduce yourself and proceed with your testimony.
Chair Becker-Finn and members, my name is Rebecca De La Hunt, and I work as the Director of Public Policy with Minnesota Family Council. On December 6, 1865, the USA ratified the 13th Amendment, which banned slavery in the United States, yet the Minnesota legislature is considering a policy in 2024 to regulate the trade of children, opening the legal door to the buying and selling of children. How is it possible to wholeheartedly support the 13th Amendment of the United States, but then try to legalize the selling of children to unrelated adults in 2024? In surrogacy, the gestational surrogate is impregnated with an embryo by IVF, either with gametes from intended parents, donors, or a combination. The gestational surrogate then delivers the child to intended parents. An intended parent could be biologically related or unrelated. Children are already facing significant mental health struggles and identity craving. What will happen when we create a sizable population of them who are cut off from their mother and/or father? Children have a natural right to their biological mother and father. We all understand that people crave to know where they're from. It's why adopted children face what is often called the primal wound. They sense the loss of being cut off from their identity. But adoption is different than surrogacy because in adoption, the child was not created with the intention of separating him or her from parents. Adoption is legally set up to facilitate children's best interests. Surrogacy provides intended parents with a product that they are sometimes willing to pay for. One is focused on justice for children who cannot advocate for themselves. The other is a marketplace for adults to pay for potentially unrelated children. These children are the key stakeholder of this proposed policy, and yet they don't have a seat at this powerful table. Surrogacy creates two classes of people, those who can buy children and the women who are often doing this to meet a financial need. Exploiting women's bodies like this is wrong. How is the renting of wombs ethical or the trading of children any different than human trafficking? It's not, and it's why I'm asking you to vote no. Thank you for your time.
All right, thank you. Are there any other members of the public wishing to testify on this bill? All right, not seeing any. We do have a couple other pre-filed amendments, so we will move on to those next. First, we're going to do the A2 amendment. Representative Niska, I believe that's yours. If you want to move the A2 and then tell us about your amendment.
Thank you, Madam Chair, and members. I move the A2 amendment. It is really a pretty narrowly tailored amendment, trying to make sure that the surrogacy that's permitted under this bill would stay within sort of the guidelines of what we heard from the testifier from the Surrogacy Center, and make sure that it doesn't ever get into a situation in which babies are being bought and sold. And in particular, there's some concerning language on page 7, line 29, saying that a surrogacy agreement may provide for payment of consideration. And so my amendment simply makes sure that there's not any selling of babies happening by deleting that language about consideration and saying that a surrogacy agreement may provide only for payment of reasonable expenses. Again, like we heard from the testifiers, we don't want surrogacy to be commoditizing women. We don't want it to be a business transaction. That was what the testifier from the Surrogacy Center said was her experience. And so if that's the experience we're going for, then we should be prohibiting the payment of consideration as part of the surrogacy agreement. So I urge members to adopt the amendment.
All right, Representative Hollins is the A2 amendment.
Thank you, Madam Chair. Thank you, committee members. I'm going to recommend that folks vote no on this amendment. While I do appreciate Representative Niska's approach to this, and especially the fact that it is narrowly tailored, what I will say is that the type of compensation that they're seeking to limit are entirely optional for agreements and part of law in a number of states, both red and blue. I mean, Vermont, Utah, Oklahoma, like this is a very normal piece of language in this sort of law, and allowing people to come to an agreement on what that compensation should look like is a part of, I think, what we would like to see. So I would encourage a no vote at this point. Thank you.
Further discussion to the A2 amendment. Representative Scott.
Thank you, Chair Becker-Finn. And just in support of the Niska amendment, even the testifier from the Surrogacy Center did say that women are doing this for altruistic reasons. If you're doing it for altruistic reasons, that means you don't do it to make money. And so I've done a fair amount of research. I was on the Surrogacy Commission that met several years ago, and this is my file I dug up. And one of the things that I found, even from the UN, and I've got some comments here from places around the world, where they took up this subject and they determined that it would be best if women were not paid over and above expenses. And because of the power imbalance that it creates, a lot of times it's poor women that are being, their womb is basically being purchased by someone with tremendous means in many cases. And so I just think that's a dangerous road to go down, and so I hope that you'll support the Niska amendment. Thank you.
All right. Further discussion to the A2? Representative Niska, closing comments on the A2.
Yes, thank you. Thank you, Madam Chair and Representative Hollins. I think perhaps other states allow it. Other states have allowed a lot of really abhorrent things in the past, but we're talking about potentially arrangements that would allow for buying and selling of human beings. And I think we should, as a state of Minnesota, draw a clear line on that. And I think members should vote yes, and and Madam Chair, I request a roll call.
All right. Roll call having been requested, the clerk will take the roll on the A2 amendment.
Chair Becker Finn.
No.
Vice Chair Frazier.
No.
Minority Leader Scott. Aye. Representative Carroll. No. Representative Curran.
No.
Representative Feist.
No.
Representative Finke.
No.
Representative Frederick.
No.
Representative Crossell.
Yes.
Representative Johnson.
Yes.
Representative Moller.
No.
Representative Niska.
Yes.
Representative Weens.
Aye.
5 ayes, 8 nays.
All right, with 5 ayes and 8 nays, the the amendment is not adopted. Moving on to the A1 amendment, Representative Scott, I believe that's yours if you want to move it and tell us about the amendment.
Madam Chair, I would move the A1 amendment.
All right, please tell us about it.
So this amendment is just a redraft to the Representative Hollins's DE that was drafted back in, I think, 2019 originally after the Surrogacy Commission work, after the commission's work was complete. And just a little bit of information about what's contained in the amendment. This does not outlaw surrogacy. It allows for surrogacy, but it narrows it to a gestational surrogacy where the mother is not related to the child, but that one of the parents has to be providing one of the gametes for the child. So in the body of research that both the Surrogacy Commission looked at, and even just going back over and refreshing today and finding some new information, they find that there's a lot less chance of a child being trafficked if at least one of the parents is biologically connected to that child. So this bill requires that at least one of the parents is biologically connected to the child. It also requires that the surrogate and the intended parents all are residents of the United States. The last thing that I think anybody in this committee wants to do with all the human trafficking going on around the world right now is send a child outside the confines of our country to who knows what, where we've lost control of that child having the rights that we enjoy as Americans and being subject to we don't know what outside the walls of this country, the borders of this country. This bill, as Representative Niska's amendment, I know it failed, but this bill says that a woman that is the surrogate will receive compensation for reasonable expenses. And it requires that the surrogate be financially secure and not on public assistance. Again, we don't want women to be renting their wombs for this, and so I think that speaks for itself. This requires the surrogate mother to be provided with a list of the potential risks involved with all the drugs and different things that are administered, and it allows the surrogate mother to choose her own physician. That's not articulated either way in this, and I feel like the mother should be able to, the best practice would be there for her to choose her own physician and not take the physician of the intended parents want her necessarily to take. Let's see, the contract in this situation would be invalid and enforceable if there was a requirement in the surrogacy contract to require the surrogate to terminate the pregnancy or use selective reduction. The best practice we found in the Surrogacy Commission was the implantation of one embryo, which would eliminate the reduction issue if that were in law. Let's see, it requires the intended parents to be married. We felt like that's just in the best interest of the child. It's a more stable environment to bring the child into. And that overall, the best interest of the child should be the deciding factor, the major factor in any of the law that we write here, and that's what this bill does. Let's see. Oh, it requires surrogacy agencies and brokers to register as nonprofits and requires all surrogacy agencies to be licensed by the Department of Health. We heard this morning in committee, and I know you weren't here, Representative Hollins, but in committee this morning, we heard about HMOs and setting up a framework. Right now, they're nonprofit, and we heard bantied about lots of concerns about for-profit. And so I think in this situation, to get away from the child or the mother, the surrogate, to get away from the buying and selling, that to have these agencies set up as a nonprofit is the way to go. And again, it just prohibits traditional surrogacy arrangements where the mother would have a biological attachment to that child. So that's that's in a nutshell what it is. There's more than that, and I won't go on, but those are the high points, Madam Chair.
Okay, that was a large nutshell.
But
Yeah.
delete all of the delete all.
Yeah, it was several pages. Representative Hollins, comments on the A1.
Thank you, Madam Chair. Thank you, Representative Scott. So the first, Minority Lead Scott. First thing I want to say is thank you, Minority Lead Scott, for having conversations with me. And I know we were texting last night about this bill, and I do appreciate your willingness to have a conversation with me and try to go back and forth, because I think that is important. I'm going to recommend a no vote on this bill. Or on this amendment, I apologize, on this amendment. As noted, it is quite expansive, and there are a number of barriers to assisted reproduction that are included in there, and a number of things that I would just strongly oppose and I think are in opposition to good public policy. So I would recommend a no vote, and I hope the committee understands where I'm coming from. I can go into more detail if you want me to, but.
At some point, it would be good to discuss the underlying bill. So any other discussion to the A1 amendment? All right.
Madam Chair, I'd like a roll call.
Yep. Okay. Roll call. Any closing comments, Representative Scott?
The Surrogacy Commission met for, I don't know, it's a whole interim. I do know that, 'cause it seems like I was down here a lot. But we really did delve into the issues, and we heard a lot of testimony on both sides, on every side of this issue, because we don't have a legal framework in the state of Minnesota for this. And I really feel like this amendment is the one that serves, it's not outlawing surrogacy, but it is putting into effect best practices to protect the child in the best interest of the child, and to watch out for those surrogate mothers to make sure that they're not being exploited. So I'd ask for members' support.
All right. The clerk will take the roll.
Chair Becker-Finn.
No.
Vice Chair Frazier.
No.
Minority Lead Scott.
Aye.
Representative Carroll.
No.
Representative Curran.
No.
Representative Feist.
No.
Representative Finke. No. Representative Frederick.
No.
Representative Grossel.
Aye.
Representative Johnson.
Aye.
Representative Moller.
No.
Representative Niska.
Yes.
Representative Weens.
Aye.
5 ayes, 8 nays.
All right. With 5 ayes and 8 nays, the motion does not prevail. The amendment is not adopted. Now moving on to discussion of the amended language. Member discussion, any comments? Representative Scott.
Thank you, Chair Becker-Finn. Let me get to my notes here just a second. I'm shifting gears here from.
If you'd like, I do have another person on the
Oh,
list if
yeah,
you want to
please.
follow. Okay.
Please.
Representative Finke.
Thank you, Chair Becker-Finn and Representative Hollins, for your bill. I just have one quick question, and I have a thought. We heard during the testimony that this bill that you're bringing isn't going to change the operationality of surrogacy as it currently exists in Minnesota. Is that correct? Is that what I heard?
Representative Hollins.
Thank you, Chair Becker-Finn and Representative Fiki. That is my understanding. It's to bring uniformity to the laws across the entire state.
Representative Fiki, any follow-up?
Yes, thank you. Yeah, I just wanted to make sure that I understand what the stakes are of the actual bill that we're hearing, which is that we're updating our language and making sure that the legal statutory language that we have is what we need for what is already happening to continue to happen in a way that legally protects everybody who's participating. And I think that, earlier, we had these two small bills to just update the statutory language to include queer communities after we legalize same-sex marriage. That's the law, and updating the language to reflect the law shouldn't be controversial. Everybody knows that same-sex marriage is legal, and we should be able to acknowledge that that's the fact. And I feel like we're kind of having a separate conversation here as well, where we're sort of pretending that what is the law isn't the law, and that we can just imagine a way for entire communities to lose their rights just because we kind of would prefer it that way. Some people may not. But like what we're really doing is updating the law to reflect the reality that includes everyone who's already doing this. So it's really, I just want to reflect that, every time there is an opportunity for us to be inclusive, we don't also have to try to imagine a world where we are completely erased. Thanks.
Thank you. Representative Johnson.
Chair Becker-Finn, Representative Hollins, I was disappointed you didn't take the Scott amendment. That was actually a recommendation for the commission that actually worked on this for a long time. I'm also disappointed that because of that, and because we're allowing compensation, we're getting into the selling of babies. I was actually disappointed by one of the testifiers on the adoption, talking about adoption. Of all these members on this committee, I'm probably the only one that is adopted.
Representative Johnson, I'll just say, I don't know that you are. So you might want to just be careful.
I am adopted.
But you might not want to assume things about your colleagues, that's all.
I said, I don't know if they are or not, but I know I am.
Yep, go ahead.
I've also, as a law enforcement officer, dealt with a number of kids who were adopted. And when they had problems, it was because the biological family got involved. The adopted parents are wonderful people. They are my parents. I have no idea who my biological parents are. I don't want it. I don't care if I know or not. But the adoptive parents adopted me and loved me like their own. So I had a little trouble during that testimony because it's not what I've seen, not what I've lived, not what I've observed in my work. We had an opportunity to make this bill a lot better, and we didn't. I'm disappointed in that. We had an opportunity to make sure that we're not into the baby selling business. But we didn't do that. So I'm going to have to vote no on this bill. And hopefully we can fix it to protect those innocent lives.
Thank you. Representative Niska.
Thank you, Madam Chair, and I'll be brief. Maybe we're just codifying what's happening right now outside of a legal code. To the degree that we're doing that, and to the degree in which, you know, some of these surrogacy agreements that are existing might be crossing the line into selling babies, I guess we don't know. But what I do know is that we're creating a legal framework for that business to happen in the state of Minnesota. That's wrong. We should be trying to figure out if that's happening and trying to figure out what we can do to stop it if it is happening, not including language in the Minnesota statute books that creates a framework and approves of it to happen. So I urge members to vote no.
Representative Feist.
Thank you, Madam Chair. Thank you so much, Representative Hollins, for introducing this bill. I dipped my toe in this policy space, and it's really, really complicated and really important. And so I'm just grateful that you have brought this bill this far. I was going to say to the finish line, but this is not the finish line. There's many steps. But I also had met with Representative Scott when I was looking into these issues, and I'm glad to hear that even though we haven't come to like full agreement, I'm glad to know that you've been part of the process in developing this bill as well. And I know I had shared my notes from our conversation way back when. So I'm really grateful for this bill. I think it's important. I know Representative Scott, when we met, you said that was the Wild West, and that's a bad state for the law to be in on something so important. So I'm glad that we're bringing clarity to the law. Thank you.
Representative Scott.
Madam Chair, well, Representative Feist, the only input I've had on this bill really is just a text back and forth on last night with Representative Hollins over the section on regulating the donor banks, which I have not delved into. I don't know much about the regulatory framework. I do know that I was texting him like, well, I think there ought to be something in place to prevent, you know, the one doctor that had like 100 kids out there. And I don't know that there's anything in this bill that prevents that. Maybe Representative Hollins can point that out to me, but that to me is unethical and just downright gross, but to think about. Members, I guess I have a question for Representative Hollins. And that is, you know, the literature that's out there, the academic literature on this subject really talks a lot about to get around this human trafficking threat. That one of the intended parents be biologically related to that child. And I'm wondering, do you have opposition to that stance? And if so, what might be your reasoning for that?
Representative Hollins.
Thank you, Chair Becker-Finn. Thank you, Representative Scott. I do have opposition to that stance, and not because of something around child trafficking. The opposition is that if there are so many circumstances where people are using surrogacy because they are unable to conceive on their own, right? And so for us to say like you're barred from it unless you can be unless one person can be biologically related to this, just seems like an arbitrary cutoff place for us to draw the line. Because I have met women who have had their entire reproductive organs removed from an accident and whose spouse has like, you know, problems with fertility. And it's like, you're saying that those people don't deserve to be able to be parents in that way. And I do find that problematic. You know, these are real world examples and real world people who have talked to me about this and who have come to my office saying that this was an issue for them. And I don't think that I can say, well, because maybe there would be child trafficking at some point in the future, you should not be able to have a surrogate in this situation. So, I mean, that is why I'm opposed to it. It's because of the real world examples that I have seen that people have brought to me that said that, you know, this just doesn't make sense.
Representative Scott.
Thank you, Madam Chair. Well, I will say this about the Surrogacy Commission. We tried to follow best practices that are out there and follow the literature for the research that's been done in this area across not just the country, but across the world. and this is what they found. And from the party that claims to be the party of science and following the science and following the fact, you're in denial. I understand there are situations where, like you just described, but there are also situations where two people that are unrelated to that child have a baby, and if you want the stories on this, I can provide those for you. From the time they receive that child, it is trafficked, and it is sexually abused. And the one story that I've read, the child dies at age 6. Okay? This is what we're trying to prevent. And when you have a biological connection to a child like that, it's a lot less likely that that's going to happen. So I hope that you'll dig into some of these issues because they're really important to the life of the child, the best interest of the child. Members, I think that we could spend a whole committee hearing on this subject. I've tried to lay out what the Surrogacy Commission found. This isn't outline surrogacy, Representative Finke, and it's not current law. Every single line of the DE is underlined, and every single line of the underlying bill was underlined. It's all new language. And there are instances where we do not adopt the Uniform Law Commission standards. And I think this should be one of them. I request a roll call on the bill, and I encourage members to vote no.
All right, closing comments, Representative Hollins.
Thank you, Chair Becker-Finn. Thank you, committee members. Same-sex couples and families who utilize assisted reproduction should have confidence that their parentage is recognized under Minnesota law. These changes will ease parentage concerns, particularly for families who have a child through assisted reproduction, or for those who opt not to get married but still wish to have full parental recognition and rights. And these changes will ensure that Minnesota remains a leader in adopting comprehensive and well-established policies to support children and families. This bill ensures that the diverse family compositions in Minnesota are fully recognized and reflected in law. It's an important and necessary first step towards advancing the larger Parentage Act goal of ensuring that Minnesota's parentage laws reflect the needs of all of our families in our state. Our state is big, it is beautiful, it is diverse, and all of those families deserve to be represented in our statutes. Thank you.
All right, the clerk will take the roll.
Chair Becker-Finn.
Aye.
Vice Chair Frazier.
Yes.
Minority Leader Scott.
No.
Representative Carroll.
Aye.
Representative Curran. Aye. Representative Feist.
Aye.
Representative Finke.
Yes.
Representative Frederick.
Aye.
Representative Grossel.
No.
Representative Johnson.
No.
Representative Moller.
Aye.
Representative Niska.
No.
Representative Weens.
No.
8 ayes, 5 nays.
All right, with 8 ayes and 5 nays, the bill is, yep, sent, I had to remember where it was going, sent to the GR as amended. Thank you, Representative Hollins. Next up, I think we've got Representative Pinto here. And I will move to refer House File 4387 to back to Public Safety Finance and Policy Committee. We don't have any testifiers signed up. Representative Pinto, please tell us about your bill.
Thank you, Madam Chair, and thank you, members. And Madam Chair, there's a letter, it's true, no testifier, there's a letter that I think was posted electronically. I have hard copies of the letter, which could be distributed. I don't know that they need to exactly, though I have them. So, Madam Chair, if you'd like to have a page do that, we can, or folks.
Why don't you tell us about the bill and we'll see if we need it.
Fair enough. Well, I guess that's a good, thank you, Madam Chair. So, Madam Chair and members, House File 4387 was driven by a friend of mine who had challenges in obtaining an order for protection against a partner that had been very abusive. And that kind of uncovered a number of gaps and discrepancies in the process of serving orders for protection and more broadly protective orders. and even in dealing when they get dismissed and making sure that there's proper notice, et cetera. Much of the bill contains a series of reforms to make that process work more effectively. Also, in Section 9 of the bill, on page 7, is a task force that's established to work on a particular issue also relating to orders of protection and domestic violence convictions, which is that in many of those cases, the respondent in the order, the defendant in the crime, the person convicted, is required to not have firearms, and yet there's been a lot of information indicating that that process does not work very well. We want to make sure that it works much better, and so the task force is focused on that process to improve how we can have that surrender of firearms, and also how we can have our first responders be safer when they are responding to domestic violence situations, which is another real concern. So that is the bill, Madam Chair, and appreciate your consideration.
All right. Are there any members of the public wishing to testify on this bill? All right, we'll move on to member discussion. All right. Seeing no member discussion, I will renew my motion to refer House File 4387 back to the Public Safety, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed? Motion prevails.
Thank you,
you,
Chair.
Representative Pinto.
Thank you, members.
All right, Representative Moller. And I will note, members, House File 4569, which was the Howard bill that was on our agenda today, is being amended and removing the section, which was the reason it was coming to us in the first place, so we will no longer be hearing that bill today. Representative Moller, would you like to move to recommend that House File 3204 be placed on the general register?
That is my motion, Madam Chair.
All right, and then would you also like to move the A2 amendment?
Yes, Madam Chair.
All right, the A2 amendment is before us, and I understand you have an oral amendment to the A2.
I think the A3 is just a separate amendment to the bill. It's not to the A2.
Okay, I think I wasn't sure if we were getting that.
And we have a written one as well. Staff worked their magic today and got
It. Oh, that's what we handed out at the beginning. Okay. So the sheet of paper you guys got at the beginning when we reconvened is the A3 amendment, which is, just to be clear, Representative Moller, the A3 is an amendment to the A2 amendment.
The A3 is just an amendment to the bill, not to the A2.
Got it. Okay. So we'll amend your motion to move the A3 amendment then.
Yes.
Got it.
All right. I think we need to move both amendments separately.
Okay, sorry, my notes are not correct. Which one would you like to move first?
We can do the A3. It's just a purely technical amendment.
All those in favor of the A3 amendment, please say aye. Aye. Opposed? Motion prevails. The A3 amendment is adopted. Representative Moller now moves the A2 amendment. Can you tell us about the A2?
Yes, thank you, Madam Chair and members. The A2 amendment, this bill has had a lot of stakeholder discussion and negotiation, and the A2 amendment is in response to some concerns that were articulated from legal aid, particularly the attorneys who handle domestic violence cases, and a letter that we had received from Violence Free Minnesota and Standpoint. And so we have addressed those concerns with the A2 amendment.
All right. Any discussion to the A2 amendment? All right, all those in favor, please say aye. Aye. Opposed? Motion prevails. The bill is now in the shape you would like. Chair Moller, please tell us about your bill.
Thank you, Madam Chair and members. This is a bill that has been in the making for quite some time. Family law issues are often complex and controversial, which is why it's rare for a major family law bill to make it through the legislature. And as I mentioned before, this bill has been in the making for a while. It's collaboration between the National Parents Organization, the Bar Association, and the American Academy of Matrimonial Lawyers. Sometimes these groups are on very different sides, but they got together to try to find common ground and improve the family court experience for all Minnesotans. They took a cautious approach with this bill, introducing substantially the same language last biennium and then introducing it this year or last year before attempting to move it this year. They received a lot of feedback in that process. I want to especially thank Legal Aid and their lobbyist Ron Elwood for devoting tremendous amount of time to the bill over the last few years, providing very valuable feedback to make the bill stronger and better.
While drafting the bill, the proponents tried to keep a child-centered perspective and focus on eliminating situations where children are trapped in the middle of prolonged conflict between their parents. There are several pieces to this bill, and I'm glad to be joined tonight by Samantha Gemberling, who can provide more details.
All right, welcome to the committee. Please introduce yourself and proceed.
Good evening, Madam Chair and members of the committee. My name is Samantha Gemberling. I am a family law attorney, and I'm here tonight representing both the Academy of Matrimonial Lawyers, the Minnesota chapter, and the Minnesota State Bar Association. So I know you have had a very long day already, so I'm going to try and move as swiftly through this as I can.
We appreciate that.
I am going to start at lines 1.6 to 1.12. This is a new addition to the statute. The rationale behind a public policy statement in this context is to make clear that the laws of the state are equally applicable to both parents, assuming that both are fit and properly able to care for the needs of the child. It also focuses on the needs of the child to benefit from a relationship with both of the child's parents and is designed to focus parents towards working together to meet the child's needs. Line 1.19 is a technical change. As I'm sure many members of this body is aware, we changed the terminology on parenting time and visitation. That happened quite some time ago. And this was just a place where there's an oversight where we need to add parenting time to the consideration in 257.025. On line 2.8 to 2.13, this is related to when people file for a divorce, custody, or parenting time action in court. They will sometimes seek a temporary hearing if they've been unable to resolve their issues in a cooperative manner. There's two changes in this proposed legislation to how temporary hearings work. Often, both married and unmarried parents manage their own parenting cooperatively, and they're able to do that for some time before coming to the attention of the court. If a breakdown in the relationship occurs, which results in a change to what's historically happened, this proposed change to the statute ensures that what the child has historically experienced with their parents is fairly considered by the court, and we think that's a very important change to make. I'm going to move on to line 3.4 to 3.2. Courts will conduct an accelerated or emergency hearing for urgent matters, like one parent fearing that the child is going to be taken out of the state. There are other serious issues that require prompt attention but don't quite rise to the level of an emergency or accelerated hearing. These issues can be dealt with in a hearing for temporary order, but often there is a long delay to get into court. Just as a sidebar off my notes, I was sharing with Mr. Lake, I was trying to schedule a hearing today in the Hennepin County court system, and it took me 20 emails back and forth. That's just to get that hearing scheduled. So one of our goals is to shorten this delay in two specific areas. The first is where a spouse is being denied necessary financial support, and the second is where a parent has been unable to see their child. These are two situations that are commonly used by one party to exercise power and control over the other. Our aim is to allow the court to resolve these high conflict issues swiftly instead of letting them fester for a significant period of time that it can take to obtain a temporary hearing. Line 3.28 to 331. This is an attorney's fees issue related to non-payment or other failure to comply with a court order. A parent can request an attorney's fee award if they can't afford to pay for a lawyer if they believe the other parent can afford to contribute. They can also request attorney's fees if another party has been unreasonably delaying the proceeding or made it difficult or expensive needlessly. However, the current statute doesn't apply in the time frame when you're trying to get another party post-decree, post-issuance of an order, to comply with an order, but you haven't yet filed a motion. For example, if you're owed payments that aren't being made, you have a duty to try to mediate that dispute first in your decree or court order, oftentimes. And so during this period, the statute doesn't cover your attorney's fees and the money that you're spending trying to cooperatively obtain compliance with a duly noted court order. So this change to 518.14 addresses that concern, so one party can't intentionally delay the proceeding and not get any consequence that wouldn't be covered by the current statute. I'm going to move on to 5.23 to 5.25. The suggested change here is to address concerns that one parent or the other may be favored in custody litigation by moving this language, which already appears in the statute, to be included in a position where the court has to specifically consider it in making custody and parenting time decisions. We've decided in our work that it's just a more elevated place for the language to be, and we think that 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 discussion is more preferable in that spot. 6.26 to 6.29, this is also a technical amendment to include parenting time, and also, as I just noted, to relocate that requirement that a parent shouldn't be favored based upon gender. Moving on to line 7.27, this change is to allow considerations for the court when weighing a modification of parenting time. These might seem like slight additions, but they're actually very important. To add both the mental health of the child and the safety of the child, considers impacts that may arise from other types of conduct that parents could engage in that's detrimental to the child, but isn't as clear as a physical abuse type of endangerment. For example, in a case where a child is resistant to seeing a parent or refusing to see a parent, refusing time with them, the court may consider what we lawyers call the in-parent, the parent who's currently favored by the child, to determine if they're perhaps engaging in some conduct that might be negatively impacting the child's mental health. If they are, more colloquial term, if they're sandpapering the child against the other parent, obviously that could be an issue that we want the court to be able to consider. There's been a lot of social discussion about parental alienation, and this is to address that type of behavior or concerning pieces that might need to be addressed for children's mental health. The safety addition is there to address circumstances where a child might be in an unsafe situation, but they haven't suffered any harm. And that's to address a concern that we don't want to wait for a situation to be escalated to injury or some actual harm to the child before the court has authority to act. Line 8.4 to 8.6. These are changes to remove references to visitation, which is antiquated under our law, and also to address school breaks, which, if any of you parents know, they're not holidays, but they need to be addressed comprehensively in a parenting time schedule, and that can produce more challenge than you might imagine. 8.12 to 8.14, that change is a significant one and was a big piece of work for us, and that's addressing the presumptive minimum parenting time. That's been extensively discussed in previous hearings before this body, so I won't go through it more, but essentially what we want to address is the fact that this 25% is a floor, it's not a ceiling. So it's not, there's been discussion, constituents have raised concern that presumptive minimum time provision as it's currently drafted is not sufficiently clear in the law so that the court could read it as that's the most that a non-custodial parent would receive, and that's not the intention. So the words "at least," while it's again a small addition, are designed to address a pretty significant concern. There's also a shift in this language to make it a little bit more child-centered and shift it off what the parents' needs are and more to the child's needs. So finally, the longest section, but the shortest comment I have is 8.21 to 11.13. This section clarifies the options that the court has to deal with violations of parenting time orders. That was a really significant concern of the National Parents Organization that we wanted to address. It addresses orders that are set or appointed by third-party neutrals as well. Many parties, to avoid court, will use a parenting consultant or someone else court-appointed, and we want to be sure that all of those orders carry the same weight as the court order, which they should. And it wants to be designed to discourage parents from withholding parenting time from the other parent, to clarify remedies and sanctions, and to strengthen the court's ability to deal with situations where parents repeatedly deprive the other parent of time with the child beyond what the court allows as far as a criminal sanction, which can be very difficult to obtain. So that is my comments. I appreciate the committee's time, and I'm certainly willing to answer any questions on the bill.
Yeah, and as you noted and Chair Moller noted, it's significant that we're bringing this bill forward and talking about it, and so I wanted to make sure you had time to fully walk through what is in the bill. We do have a couple people signed up to testify. I have George Rerat and Molly Olson. Ms. Olson is here. You can go ahead and come up closer to the table, so when it's your turn, you're ready. All right, please introduce yourself for the record and proceed.
Thank you, Chair Becker-Finn and members. My name is George Rerat. I'm the Acting Director of Advocacy for the Minnesota Shared Parenting Action Group. Minnesota Shared Parenting Action Group is the largest Minnesota-based the largest Minnesota-based support group for children and families focused on Minnesota family law and its impact on children and families. We have over 12,000 members, many times that of what the National Parents Organization has here in the state of Minnesota. The Minnesota chapter leader for the National Parents Organization is in Florida. They aren't here in Minnesota. So when we talk about, consultation, we are the group that should be discussed, these issues should be discussed with. We did have a group that was formed in 2019 after the last family law discussion. In 2019, we met with both the Bar Association and the AAML. We met with them in 2019 and in 2020. There were no agreements reached on issues that are addressed in this bill, HF 3402. None, zero agreement. We have not been consulted at all by anybody, which I think is not really a best practice that we'd like to see from our House of Representatives. I do certainly respect Representative Kelly Moller's dedication to family law issues. We have a lot of concerns regarding House File 3402. The citizens of Minnesota desire for well-considered, well-vetted, well-discussed legislation. HF 3402 does not meet any of those requirements.
And I'm going to have to ask you to wrap up.
Okay. If I could just have one more minute, I'd appreciate it.
Well, then I have to give everybody another minute, and all the testifiers were told ahead of time that they had 2 minutes.
Oh, I'm sorry.
The timer just went off,
I just
so-
heard Samantha Gaberling talk for much more than.
That's different. That's the
Okay.
author
All right.
testifier.
So I respectfully-
Sir, you got to let me finish talking. The author's testifier is allowed to walk through the bill. It's a different process. It's the same on either side. We had folks sign up, and we've allowed you to speak for 2 minutes, and I need you to wrap up.
Okay. I respectfully request that Representative Moller withdraw HF 3402 for consideration by this committee, allowing for discussion and collaboration. Should the bill proceed, I would urge a vote of no. Many committee members and authors have been led to believe that HF 3402 reflects a consensus. That is not accurate.
All right. You're not wrapping up, sir. You just went ahead and took the extra minute that you asked for. So this is how this works.
Okay. All right. Thank you.
Thank you. I have Molly Olson is next, and then Tim McCusker is on deck.
This way,
Okay, welcome to the committee. Please introduce yourself and go ahead with your testimony.
I'm Molly K. Olson, the founder of the Center for Parental Responsibility. CPR mission, remove the obstacles that prevent both fit parents from being fully and equally involved in the lives of their children after divorce and separation. For 25 years, I've advocated for family law reform as an unpaid citizen volunteer. I've participated in 6 collaboration task forces and presented 1 to 5 bills every single session for 25 years. I send all legislators these flyers on a regular basis, educating you on all of these issues. Despite this track record, I was unaware of this bill or its promoters until recently. I was never approached for my input, despite having worked in 2019 and early before COVID with this group on these issues, but we were not able, as George said, to reach resolution, but since then I have not been spoken to. While some issues in this bill do need attention, the devil is in the details. Too much verbiage is too vague to claim any positive improvement. Ambiguity creates conflict. This bill will do very little for very few parents going through big challenges in family court. I have 7 pages of specific concerns, including solutions that would make this bill better. 3 examples are: 1, the bill mandates a hearing remedy for denied parenting time
time. But the way this bill is written, one parent can still deny the other parent 26 days a month, and the deprived parent will not qualify for relief. Minimal enforceability. 2, the bill purports to get tougher on enforcing adherence to court-ordered parenting time. While this sounds good, it's not a new concept, yet it's still unclear what constitutes a protected, out-of-court, informal, real-time agreement in writing. 3, the bill includes benign technical changes 10 years long overdue. What is wrong with this process that simple changes take 10 years? Reason, from my experience, the divorce lawyer lobby is given primary control of all family law statutes, same as it being vested interest tobacco companies having first and final say on all smoking laws.
And I'll need you to wrap up.
So there are very things missing from the bill: technical changes, lingering oversights, and more positive impact changes. And it is my request that comprehensive amendments are needed to truly prioritize the benefits of fit parents and children. So far, I have no commitment from the author as of this afternoon to meet face-to-face to address these issues. I think it's better to have no bill than a flawed bill, and please vote no or table this bill until it can be improved.
All right, thank you for your testimony. Next up, I have Tim McCusker.
Chairs here.
Welcome to the committee. Please introduce yourself for the record and proceed.
My name is Tim McCusker. I'm a retired engineer. And I want to just thank the chair and the committee members for allowing me to testify today on House File 3204 and to Representative Moller. Again, my name is Tim McCusker. I was an affected parent of these child custody laws in the past, and now my children are old enough to be subject to these same antiquated bills like this. In fact, the introductory public policy statement of this bill includes ensuring that each child has frequent and substantial contact with the child's parents. Unfortunately, the rest of this bill does little, if anything, to live up to the spirit of this statement. Let's consider a metaphorical example. This bill, with this proposed minimal 25% parenting time for non-custodial parents, is like patching a leaky pipe with duct tape. Consider how much the demographics of our society have evolved over the last 50 years. Today, most women are not only working, but also obtaining college degrees, challenge traditional gender roles of years past. In fact, the chair and nearly half of this committee are working women, and coincidentally, all members of the St. Paul City Council are working women. Despite this progress, our family court system has been painfully slow to adapt. Even within progressive circles like the Minnesota DFL Party, meaningful change has been oddly elusive over the past 50-plus years on this issue, and so we stay regressed in the past century. I've spent over 2 decades witnessing and testifying for a starting place in law of equal shared parenting, yet progress continues to be wholly insufficient. We continue to nibble around the edges, applying more duct tape like this instead of implementing meaningful reform like equal shared parenting. Will I be sitting here before you in another 20-plus years from now saying the same thing? Why not prioritize a model that fosters cooperation and equity and reduces or eliminates conflict from the start? Isn't it time to move beyond duct tape solutions and embrace equal shared parenting as a standard? Let's build a future where every child has the opportunity to thrive with the love and support of both equally involved parents. Thank you.
All right, thank you. Any other members of the public wishing to testify on this bill? All right, we will move on to member discussion. All right. Chair Moller, closing comments.
Yeah, thank you, Madam Chair and members. And I just want to say that this has been a long time in the making. As I mentioned before, this was introduced last biennium. It was also introduced last year to give people an opportunity to look at it and provide feedback. I did meet with that group today, and I have asked for them to submit their 7 pages to me in writing. I want to thank all of you who've signed on to this bill. This might be the bill that I've ever had the most Republican co-authors on, and so I really appreciate that, and also Representative Scott, really appreciate your leadership in this area over the years. So with that, Madam Chair, I hope members can support this bill.
Yep, and I will also note for the record that this has historically been, as you noted, a difficult topic. I know I personally have gotten more threatening emails and aggressive lobbying is, I guess, how I'm going to put that on this issue more than any other issue. And so I thank you for carrying the bill and working with Representative Scott. Sometimes the mark of a good compromise is that nobody's totally in love with the bill, but I think this is an important, notable step. So with that, Representative Moller renews her motion to recommend that House File 3204 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. Last bill, Representative Scott. Representative Scott, would you like to move to recommend that House Bill 2895 be placed on the general register?
Yes, I would, Madam Chair, and I do have an oral amendment. I think we got that, or is it a written one?
I think we've got the A1 amendment, and then you also have an oral amendment, is my understanding?
Okay, yes.
Okay, so the A1 amendment looks like it's just changing effective dates from 23 to 24. That's the A1, so would you like to move the A1?
I'll move the A1, Madam Chair.
All right, all those in favor of the A1, please say aye. Aye. Opposed? All right, the motion prevails, the amendment is adopted, and then it's a good thing I'm allowing oral amendments today so we can clean up these bills. Representative Scott, if you want to tell us your motion with the oral amendment.
Right, with the oral amendments, Madam Chair, thank you. This bill regards spousal maintenance, and one of the changes that they're making is that they are changing language so that they're getting rid of language that is usually the language now is temporary and permanent, and we're changing that to transitional and indefinite. And so on line 2.3, the change would be to strike temporary and insert transitional. And then strike permanent and insert indefinite.
All right, I got that. Perfect. All right. All those in favor of Representative Scott's oral amendment, please say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Representative Scott, please tell us about your bill.
Madam Chair, thank you. This bill represents a pretty significant reform in spousal maintenance. The statutes have not been touched meaningfully for several years, and the main problem with our current statute is it gives insufficient guidance. As a result, parties don't know what the likely outcome of their case will be, and therefore they struggle to come up with their own agreements without resorting to litigation, which should, in my mind, always be the goal. The purpose of this bill is to give parties and courts better clarity, certainty, and predictability. We're aiming to achieve fair and equitable results while also preserving flexibility to deal with changing circumstances. And this includes addressing the issue of retirement, which has really never been brought to bear on this area of law. Discussions about this legislation began back in 2016, and it's been carefully calibrated and developed. And Samantha Gimberling is back with us for round two, second bill here, and I will turn over to her further explanation.
All right, I will note, I also clerked in Hennepin County Family Court, so it's like a blast from the past today with all these family law attorneys.
Family law lawyers.
Please introduce yourself again for the record, and then go ahead with your testimony.
Good evening, Madam Chair, members of the committee. My name is Samantha Gemberling. I'm a family law attorney, and I'm here tonight representing both the Minnesota chapter of the American Academy of Matrimonial Lawyers and the Minnesota State Bar Association. As Representative Scott has previously noted, we started working on spousal maintenance reform on a constituent request in 2016. This bill this proposed statute was developed in consultation with many other parties, and the Bar Association, Representative Scott, and Senator Westland, who is carrying the Senate companion. What drove these changes was a frustrating lack of consistency and predictability in spousal maintenance cases. Litigants face very different outcomes depending on which judge they're in front of, even when those judges are in the same courthouse. Because they can't predict outcomes, parties struggle to reach their own agreements and are often driven to litigate. With this bill, we're attempted to provide some clarity and direction for the courts and parties, allowing sufficient flexibility to account for the diverse circumstances that faces parties in every different maintenance case. We wanted to replace dated language and ideas and address change in circumstances that aren't currently in the statute, like retirement. So I will again quickly walk through the changes to the statute. 1.15 to 1.16. We struck out through appropriate employment for several reasons. It is not to imply that there shouldn't be a consideration of appropriate employment, but that consideration can be captured in all relevant circumstances. For parties with significant means, there may be enough assets to make maintenance unnecessary because people have enough money from those investments to obviate the need for maintenance. But parties at all wealth levels frequently litigate about what appropriate employment means. Courts and parties will be better off if they focus instead on the phrase immediately prior, all relevant circumstances, which could include employment if it's relevant to the situation. Employment will remain a factor under an analysis of all relevant circumstances, but we're just trying to remove it from being something that people have to fight about and litigate. Moving to 2.13 to 2.14. This is an important change because many couples use debt to fund their standard of living, and they live beyond their means. After a separation, maintaining the same lifestyle becomes really difficult, and it would be unfair to use a standard of living that the parties never could actually afford. Line 2.15 to 2.18. These changes are a modernization of the statute, retaining the consideration that one party may have given up opportunity to benefit the other party, but not limiting that to homemakers. It still allows the role of both spouses to be considered. 2.22 to 2.23, the change to add mental or chemical health of both spouses. This previously only focused on the spouse seeking maintenance, and it's more fair to look at the potential payor spouse as well. Line 3.2 to 3.24. How long maintenance will last is perhaps the key discussion in maintenance cases. Many other states address this with statutory durational guidelines like we're doing in this bill. This is the single biggest change to the framework of maintenance in this bill. This will increase clarity and predictability for parties, and that will reduce litigation. It's also important to note that the guidelines are not set in stone, they're rebuttable, so courts can go outside them for guidelines that don't fit a particular, if the guidelines don't fit a unique situation. Finally, the words meet the expectation. And I know, Madam Chair, you probably heard this often when you clerked. When you're talking about permanent maintenance, that implies that it is permanent and it will never end, and that is not correct. It's permanent until it's changed by subsequent court order. Similarly, temporary maintenance is really transitional maintenance designed to move a party from the recipient of maintenance to get ready to make a life transition, to enter the workforce or to increase their earnings. So we're getting language that people can readily understand and understand how it's going to apply to them and to their life. 3.27 to 3.29. The goal of this provision is to resolve any ambiguous orders or agreements to clarify that the obligation to pay spousal maintenance does indeed and should terminate when you are no longer alive and when your spouse remarried. And you would think that is something that doesn't happen, but I have myself litigated someone who's remarried and said they should still be entitled to maintenance from their former spouse. 4.3 to 4.31, the modification statute. This presently exists in a different part of Chapter 518, namely 518.39. The goal is to move modification into the statute to make it clear what the requirements are to modify and to align all maintenance issues in one part of the statute. So while it looks like a pretty substantial change, it's really a move more than a change. There's a technical change at 5.3, the cohabitation statute, just to make clear that modification that I just mentioned, that just refers back to 5B, which would be the modification standard. Probably the second most significant piece of this bill is the addition of Section 7 in retirement. That's at 5.24 to 6.16. The current statute doesn't say anything about how retirement should affect requests to modify maintenance. This means that a party approaching retirement age faces a lot of uncertainty. The bill provides parties and courts factors to consider and addresses certain certain occupations that have mandatory retirement ages like air traffic controllers. The bill sets an expectation that both parties are also expected to use their assets for living expenses during retirement, which will eliminate a lot of litigation about whether parties should be allowed to preserve assets for their heirs rather than living off their retirement that they saved for and that they were awarded in the divorce. So the retirement piece will be really impactful in practice and will allow people to not pay maintenance into their 80s and 90s is the goal. I did not make any comment on the form, but that's self-explanatory, I think, and I would not have any other comments unless anyone on the committee has questions. We appreciate the time.
All right, yeah, thank you for the walkthrough. Again, this is a big deal to move this forward, and I appreciate you walking through it. Are there any members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. Representative Scott, I feel like you and I are the ones who know the most about this topic already, so Representative Scott, closing comments.
Would appreciate your support. I appreciate Ms. Gimberling being here and for her work, and I know Victoria's up there too, and Brian Lake, and this is, I think, an important move forward.
Absolutely. With that, Representative Scott renews her motion to place House File 2895 as amended on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. Bill is on its way to the general register. With that, members, we are done for the evening. I want to thank staff, Sergeant's office, the pages, both partisan and nonpartisan staff for sticking with us on these late nights. With that, we are adjourned.